Welcome to the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the City Bar.
Thank you for joining the New York City Bar Association podcast. I am Theodora Florent, here with my co-host and colleague, Jose Landivar, and we are attorneys and members of the New York City Bar Association's Copyright and Literary Property Committee.
On today's show, we are welcoming Scott Sholder, co-chair of the litigation group at Cowan Debates, Abrahams and Shepherd LLP, one of the leading law firms in media and entertainment. Scott is a frequent writer and speaker on issues related to copyrights and trademarks.
Scott was also featured in the Hollywood Reporter's Power Lawyers for 2024 and has represented world-famous authors in a copyright class action litigation concerning the unauthorized use of literary works for generative AI training. Scott is also a fellow member of the Copyright and Literary Property Committee and is the chair of the AI subcommittee, whose mission is to keep tabs and stay current on the latest developments at the intersection of copyright law and generative AI.
Scott is on our show today to update us on some of these developments, discuss how Taekwondo and music shape his practice, and we will get his thoughts on what it takes to be a successful litigator in 2025.
Scott, welcome to the show.
Hey, thanks for having me.
As we mentioned in our introduction, we have a lot to cover about law and artificial intelligence, but before we dive in, we wanted to ask you about music. Can you tell us more about your love of music and the role it played in your decision to become an attorney?
Sure. Yeah, music actually was the reason I decided to become an attorney. And it sounds a little counterintuitive, but I went to college in DC at American University, and I went in not knowing what I wanted to do. I think that's probably true for a lot of freshmen in college, not really knowing, well, what's my major? I don't know. I'll figure it out as I go. Yeah. And by junior year, I still had to declare at some point. I think I declared in sophomore year, maybe. So my bachelor's is in journalism, and I really liked writing. Knew I wanted to do something in that space. And so because I'm such a big music fan, I was a music writer for the paper, doing concert reviews and CD reviews and band interviews and things like that. And then I became the music editor for a year or so. And I liked it, but the newspaper business just wasn't clicking for me. And it wasn't until I took a course in communications law that was required for my major that I realized, oh, okay, I can see where the intersection comes in now. First Amendment, free expression, privacy, intellectual property. And that course really is what made me decide to go to law school. And I kind of put two and two together that I could go to law school and do something entertainment related and music related. So I was like, all right, I'll go to law school and I'll be a music deal lawyer, music transactional lawyer. This was like the Napster days. I went to college in 2000 to 2004 when file sharing was all the rage. I interned at the RIAA and started really focusing on kind of learning about music industry and business and the legal concepts behind it. And that really was my motivation to go to law school to begin with. Now, obviously, I ended up going down a slightly different path. I certainly do music work, but I'm not a music transactional lawyer, that's for sure. But certainly was the inspiration for going to law school to begin with. I was just such a fan of music and art and creativity and really just wanted to do something in that space.
Yeah,
Amazing.
that's great. So since we're on the topic of music, there have been a few interesting music copyright cases recently. Two that spring to mind are structured asset sales versus Ed Sheeran, where the owner of Marvin Gaye's Let's Get It On asserted infringement against Ed Sheeran's hit song Thinking Out Loud, and Larval Publishing versus Dua Lipa, where the owner of two lesser-known disco songs, Dom Diablo and Wiggle, claimed infringement against Dua Lipa's hit song Levitating. In both cases, the courts found that the plaintiffs failed to show substantial similarity and that any similarities that were proven were unprotectable elements like chord progressions, ascending scale, single note, only drawing inspiration from earlier artists. Do you think it's easier now than ever, in a way, with borrowing from music from earlier artists? And is it getting harder for plaintiffs to win these types of cases?
Yeah, I think to some degree, everything is based on something else. And the more content that there is out there, the harder it is to distinguish one thing from another and to argue that something is truly original. So I think the more and more content that's created, it gets harder and harder for one particular creator to say that person must have copied me. There's a lot of, you see it, you saw it in the Ed Sheeran trial, how many songs over how many decades used that specific chord progression as a foundational element of the song. So to say that one artist must have taken from one specific song, that's just hard to prove. So I think the short answer is yes, it becomes harder to prove infringement as a plaintiff when there's so much content out there. And it kind of boils down to ideas and structural building blocks of creativity are not protectable. Styles are not protectable. It's the specific expression of that style. And it's hard to prove that. It gets harder to prove that when there's more content. But there's only so many ways you can make a song that is pleasing to the ear and fits within your genre and whatever kind of aesthetic that you're going for. And so you need those building blocks. So yeah, I think it is getting harder for plaintiffs.
How successful are like the selection and arrangement arguments? Does that ever really work?
Yeah, I mean, the thing with selection, arrangement, coordination is that if you're dealing with things that are themselves unprotectable, the copyright in that is going to be thin, right? It's going to be less robust than if you were just protecting something that was purely expressive or a combination of expressive things, a combination of independently copyrightable elements. And so you'll have to show verbatim or near verbatim copying. And so that makes it even more difficult. So it is a really good argument. It's a good fallback position, especially, and I'm sure we'll talk about AI later, but when it comes to things that are created using AI and you're relying on that selection, arrangement, coordination that was done by a person, the standard is just higher. So it's a good tool to have in the toolbox for litigating these claims, but it is certainly harder. It's a higher bar.
But it helps to like maybe prevent the case from getting thrown out, right? Maybe it's like a good sort of tool block to kind of keep that case in the courts.
Yeah. I mean, certainly you can't bring a case. You can't bring a case based on an idea or facts or something like that. And so you really need to make sure that your complaint is grounded in something that is protectable. And if all you have to go on is the combination of unprotectable elements, then that's what you got to do. And if you plead that plausibly enough, then you should be able to avoid a motion to dismiss at least. That doesn't mean that you'll win, but you'll at least get past that first hurdle.
And so turning to like the market incentives, I know a lot of record labels and private equity companies have been purchasing music cataloged by artists. Like there was a big deal with Queen and Bruce Springsteen recently. Do you think like the fact that these private equity companies that have incentives to make money, litigation, a vehicle that they might use to generate money, or is it really a loser? Is litigation just really a cost loser more than a profit center?
I haven't done that analysis. I don't know, like from a business standpoint, the profit margin or what these companies stand to make. But I have to imagine that some people who are much smarter in business and math than I am did the calculations and determined that purchasing these catalogs is going to be really profitable. So if somebody is infringing on the rights that were acquired by these companies, then yeah, I would think it would be worthwhile to litigate. You have to, as with anything, any legal dispute, you have to really do a cost benefit analysis of what's the cost to litigate, which is a lot, versus what do you stand to gain. Like that's always going to be fact dependent. It's going to depend on what the defendant is doing and what the value of the work is. I routinely advise clients against my own financial interests as a litigator to not litigate, because you get an artist that has a claim that could be worth a couple $100,000. That's really significant money for most people in small businesses, and you'll spend more than that in the first year of litigation. It's unfair, but that's kind of how the system is.
So, Scott, you touched upon the impact of the costs that come with litigation. and also just the intersection of music. A few high profile cases involving generative AI are making their way through the courts. One specifically involves music publishers suing Anthropic for using lyrics to train its Claude chatbot to write songs, and the others involve major record labels suing Udio and Suno, two AI music companies, for generating music that sounds very close to existing recordings. We want to know what you think is at stake for artists and record labels in these cases, and what role you see litigation playing in establishing the boundaries for how generative AI can use musical works.
Well, I think what's at stake is kind of the same things that are at stake in the other litigations in the publishing industries for authors, for newspapers, news organizations, and visual artists. It's the not only is it the income, possible lost income and licensing opportunities and economic interests, but it's the control over your work. Part of owning the copyright in something is being able to authorize people or not authorize people to use them and use things in certain ways. And I feel like, especially given how ubiquitous music is, kind of all over the place, how many streaming platforms there are now. I know the record industry is different from how it used to be, or people aren't buying CDs and things as much anymore, but there's a lot of streaming platforms, a lot of different forms of income. Say what you will about the amounts that are paid, but there are systems in place for artists to get paid, and it's kind of a combination of potential loss of livelihood and lack of control of your rights, what your material is being used for, and kind of what comes out the other end. Debates over whether output have got infringing derivatives or if something is substantially similar in the output and who's responsible for that. But that also leads to a glut of content. We were talking a couple minutes ago about how much content there is out there. If you can generate a song with the click of a button, that just means all the more content because it's easier to make. And there's positives to that. People can be creative in ways that they weren't able to be before. If somebody is not a natural musician, they're still able to exercise that creativity. But there's two sides to every coin, and that the other side of that is that you get kind of a flooded market and dilution and content getting lost. And what people will argue as human created content getting lost in a sea of AI generated content, and what are the implications for people's ability to earn a living off of that when there's that much stuff out there. Oh, and you asked me about the role of litigation. Do you want me to go into that?
Absolutely.
Right now, the role of litigation is really going to be testing the boundaries of what can and can't be done using content to train AI models and generate new content. There's no legislation really on the horizon that is going to take care of any of this or clarify any of this. I don't know that I will get into whether executive orders on copyright issues are or are not appropriate or constitutional. I'm not a constitutional scholar, but at this moment, there's nothing out there anyway. I don't think the president can declare what is and isn't fair use, but we don't really have regulation aside from certain states setting some guardrails for safety and privacy purposes, and transparency. But the courts really are the only places right now that are determining what are the boundaries of copyright laws as it applies to AI. And we get guidance from the Copyright Office, but you're going to have there's 40 some odd lawsuits right now, some class action, some not class action. And I think just as a matter of statistics, it seems like there will be some conflicting decisions and lots of different fact scenarios. And so you're going to get decisions at some point from many of these courts. There's going to be appeals. Maybe at some point you'll get up to the Supreme Court on an issue, whether it's fair use or not, and whether it's generally applicable or really fact specific remains to be seen. So we'll get some answers at some point from the courts. And I think the role is really important at this point because there's no other way to really test the boundaries and determine what people's rights are.
Yeah, there's no denying that AI is like the hottest topic in copyright law today. And it's only been in common use for just a couple of years. So what initially sparked your interest in AI? What motivated you to become a speaker on the subject very early on in its adoption? I know you were one of the first people on the copyright committee to start talking about AI and bring it to our attention. Would you like to describe yourself as a forward-looking thinker?
I think so. I mean, I'm definitely not an early adopter of technology. I will admit to that. I did not have the first iPhone. I was not the first to use ChatGPT or try out the Google Glass or the Meta Ray Bans or anything like that. That's just not who I am. I wait to see kind of how things develop. I think I have to give some credit to one of my former partners, Ben Halperin, who I was talking to about these issues when Crayon first came out, which was the kind of the first iteration of DALL-E. And he had written, it was a LinkedIn post or a blog post on the CDAS website about kind of musing about some copyright issues. Is this protectable? Who owns it? What do the terms of service say? And he and I started to get to talk a lot about the copyright issues in AI. And that's what really sparked my interest. I started seeing stuff online, posts about people putting images up and it's like, oh, isn't this fun? I can go into this little program and tell it to, I'll give you the example I always use. And I've generated many images of this, a squirrel riding a bicycle. Don't know why that's my favorite thing, but it's the thing I use in presentations to get a laugh. Oh, I can just tell it to do that and it'll pop out and it'll be funny. And okay, it's kind of a novelty, but he and I started talking about these things and I started seeing more and more of it online. And it really sparked an interest in like where is this going in terms of copyright? And as a copyright lawyer, like, do we know who owns this? Is it protectable? What do the terms of service say? And so I got into writing more about that. I think Ben and I wrote a joint article or blog post at some point, and I started just writing a lot on LinkedIn and kind of reading on my own, playing around with some of the platforms, and it just became a kind of a real deep point of interest for me. And yeah, in terms of forward thinking, I guess this was an instance of that where I kind of saw that this is going to be a big issue. And I think a lot of copyright lawyers did. I'm not alone in this. I'm not the only one who was thinking about it, but I did start to kind of really write about it and take advantage of the fact that it was a novel issue and start to dig in because it obviously is kind of the future of a lot of things, including copyright law. And I could tell it was going to be, and that the litigation floodgates would open sooner rather than later.
Scott, thank you for that. I think that it helps for us to have a better understanding of how your approach to AI helps you make better judgments for future cases for your clients, especially with the analogy of the squirrel on the bicycle. Based on these recent experiences, whether it's testing out the different types of AI programs and anticipation for future cases that you might be faced with, what lessons do you think you've taken away about how the law is dealing with artificial intelligence? And are there particular areas in copyright law that still feels a little unsettled where the most urgent attention should be directed?
Yeah, I mean, I think that the two major, working kind of backwards, the two major areas that are, I guess, unsettled would be the protectability question, protectability of output, and fair use. Protectability of output has been dealt with by the Copyright Office in a couple of different publications and in decisions concerning registrability of AI generated work or work that contains AI generated content. And so there is some more clarity on that, although there are cases working their way through the judicial system about that issue, kind of challenging the notion that you need human authorship in order to gain copyright protection. And fair use is the centerpiece of most, if not all, of the lawsuits that have been filed. So that's really the unsettled area. And I think one of the kind of lessons from being involved in these cases and observing the other litigations that have been filed, just like anything else, the fair use inquiry is really going to depend on the circumstances of the case. And these programs are, each one is a little bit different. The facts behind where the training data came from, how it was procured, how it was used, how the program actually treats it, and what happens kind of under the hood. The fair use is meant to be it's not a rigid test, right? It's 4 factors. They're not exclusive. Courts don't tend to go that far outside of those factors. There are other considerations, obviously, but they really have to look at the facts of the case. And there are so many different models and so many different cases now. And whether it's visual, text-based, music, video, you're going across genres, across disciplines. And I think that's why things are so unsettled and unclear at this point, is you're in different courts with different parties and different facts. And so that's why I don't know that we're going to get a straight answer, kind of like a big picture answer, unless there's some Supreme Court or appellate decision that gets us there.
The New York City Bar Association is a dynamic community of over 23,000 legal practitioners. Members shape the future of the legal profession, serve the public, and gain an edge in their careers. To learn more about becoming a member of the City Bar or to join today, visit nycbar.org/join. Save 20% on semi-annual dues when you join. Call Customer Relations at 212-382-6663 and use code POD24.
You've handled class actions, and like the Anthropic case we just discussed, these cases have involved a class of artists suing AI companies for using their works and training models without compensation. Defenders of AI companies claim that such use should be lawful under precedent. One solution discussed meant to address this conflict is a licensing market where AI developers would pay licensing fees to copyright owners to use their work. But others say that licensing fees would hinder AI development since companies would be forced to spend large sums of money to cover the cost. What are your thoughts on creating a licensing market for AI development? And do you think it's an adequate solution for the stakeholders involved?
Yeah, I mean, I think so. I'll start by saying that there already is a licensing market, and it's been developing for a while now. And you can just see media reports on deals that the AI companies have made with news organizations and publishers and image content, stock content houses. So there is a market. It's growing, it's developing, it's out there. It's been out there for a little while. And I do think that's where these things should go. Whether it's individual deals, whether it's some sort of collective licensing structure, kind of like the music PROs or the MLC. There's a lot of different ways to do it. Again, people much more sophisticated and knowledgeable in the technology and in the kind of logistics of setting up that kind of architecture will hopefully figure these things out. But I think that's where things have to go. This happened to me. I analogize this again to the music industry, where you had kind of a whole flurry of lawsuits in the 2000s over copyright infringement for file sharing. And we ended up in a place where there were deals put in place and platforms like Napster became essentially licensed, but they became kind of real legal entities, and Napster doesn't really exist anymore. But now you've got Spotify, you've got YouTube Music, you've got Apple Music. Everything has gone to streaming. And again, as I mentioned before, people certainly have complaints about how that compensation structure works and whether it's fair. Putting that aside, it's there, and the licensing structure was built and the organizations were created to handle these types of tasks. And I think that is what should be done in this context. Obviously, it's a bigger picture because we're talking about more than one industry, but there are organizations that are starting to do this and starting to think about how these licensing structures will work. And I think that's really the only way to ensure that people get paid fairly. And yeah, you'll always hear from the tech side that this is going to hinder development of the technology or innovation. I think, I don't know for sure whether that argument was used back in the music industry disputes in the early 2000s, but if it was, we're still here. We've still got great streaming technology, didn't stop developing. I think it's overstated, especially, look, you have to take these positions in litigation, but I don't think it will ruin innovation. I think there are ways that everybody can have their interests satisfies it's probably putting it too strongly, compromise and good kind of settlements. I say settlement, not in the legal sense, but everybody's going to lose out on something. Everyone's a little pissed off. Like, that's how you know it's a good settlement, if everybody walks away a little annoyed. So not everybody's not going to get everything that they want, but I think there's a way to make it work.
Scott, touching upon the fairness behind settlements out of litigation, are there any areas in copyright law where you see artificial intelligence transforming or impacting how attorneys work or interact with clients? For instance, we just touched upon the whole licensure procedure when it comes to licensing under streaming devices, streaming platforms. How have you personally adapted to AI in your practice? You touched on this a little earlier, but would you be able to delve a little bit more about how it impacts your day-to-day practice?
So I don't, in terms of like using it for practice, I don't really use it that much. There are AI features built into a lot of legal tech platforms, whether that's Westlaw or whatever your e-discovery platforms are. We've got some AI type features in our e-discovery platform that allows you to summarize documents or engage in predictive coding to make document review more efficient. Microsoft has Copilot that helps, again, with kind of finding documents and summarizing documents and kind of administrative type tasks like that. I don't use AI for drafting. And I mean, look, people will have their own opinions on this, but I don't think it's at a point where I would trust it to draft a legal document. In any circumstance where you're using it to draft something, it really should only be for literally drafting, like a first draft, ideation. It has to be reviewed and edited and tightened up and vetted by a human in order to make sure that it's not hallucinating and not doing anything else that could get you in trouble, especially in legal practice. Lawyers have gotten into a lot of trouble having ChatGPT draft their briefs, and then they don't check the cases that are cited, and some of the cases end up being made up. Lawyers getting sanctioned for it. It's, lawyers have ethical obligations to understand the technology that they're using, but it boils down to a much more basic idea of like, site check your brief. That's it doesn't matter what tool you use. You still have to make sure that what you're saying is accurate.
Exactly. Where do you think attorneys face these ethical challenges in using AI? We've heard quite a number of cases where there have been some attorneys unethically referencing made up cases that have no reference or no connection to the cases, and they have been reprimanded because of this.
I think the biggest problem is a misunderstanding of what the technology does and how it works. In one of the cases that you mentioned where a lawyer was sanctioned for citing cases that didn't exist, there was some indication that they thought, or someone on the team or the client thought, that this was some kind of super powerful search engine that just, I guess, could do no wrong. And that's not what it is. It's a predictive machine. It predicts statistically what word will come after another word based on the patterns that it's detected in the training materials. And so if it doesn't know things, right? Like, I try to push back as much as I can on anthropomorphizing these machines. It's not like a human brain. It doesn't understand things like a human does. Gives you what it thinks is the answer. And if it doesn't know the answer, sometimes it just makes it up. And so that's really where you have to understand what you're getting. Like, what is it doing and what is it spitting out? And knowing the risk that there is something in there that might be inaccurate, you just have to go back to your basics of professional responsibility, which is proofread and site check your brief and make sure that the cases are still good law, and then in taking it a step further back, make sure the case exists. And God forbid you submit something with a made up case, own up to it. I mean, you can't some lawyers have doubled down on insisting that these cases do exist, and you get in even more trouble. Like, you make a mistake, just own up to the mistake. It's very tempting because it makes things easier and makes things faster and more efficient. And I think there are ways in which it can make legal practice faster and more efficient. cost effective for clients, but you really have to watch out for the pitfalls.
Absolutely. Touching on being able to catch those pitfalls and the fact that we previously discussed one particular area of copyright law that still feels a little unsettled, we wanted to hear your additional thoughts on the fair use defense being raised by generative AI companies. A typical defense seems to be that their use is transformative and that any copying is trivial or minimal given the massive amounts of data points used to generate a single answer. On the other hand, there are other factors such as market impact and the character and purpose of the use that seem to weigh against finding fair use for AI companies. Would you be able to speak on how you see courts approaching fair use in the context of generative AI and which particular factor you think will have the most impact as case law develops?
Yeah. I have to be a little careful just because I'm on these cases. So I tread a little carefully, but I mean, I think you won't be surprised at all that I don't think that this is fair use. I'm certainly not an unbiased source, but I do sincerely believe that. I mean, I think the first and the fourth factor are going to be the most important. I don't think the intent of the four factors is to allow for this kind of mass copying and use. And so I'll dig into that a little bit. The first factor, purpose and character to use, and the fourth factor, market harm, are always going to be the most important. Second and third factors are always considered. Then there's things that kind of fall outside the four factors, like bad faith and public benefit and things like that. Courts will do what they will with those. It's unclear where those really stand. But the fact is that I don't think there's any dispute that in the entirety of many works were copied. So the third factor seems to me to be pretty clear, although you can then counter argument to that is what was the purpose of the copying and did the entire work need to be copied? And was it reasonable for the purpose and for what they argue is transformative? So those, and the nature of the work is going to depend on the case. And in the Authors Guild case, we had a class of fiction authors. It's obviously been combined into an MDL, so it's all a little bit different now, but at least at the outset, fiction is as close to the core of copyright as you can get. The companion case with the nonfiction works, I don't think it was really any different. Nonfiction certainly can't protect facts, but nonfiction works are highly creative. And I think by and large, when it comes to copyrightable works like art and books and things like that, you're going to come to the core of copyright, and the third factor will weigh in favor. Sorry, the second factor will weigh against fair use. But the first and the fourth is really where the rubber meets the road. Is the use transformative? And what use are we talking about? Are we talking about the downloading? Are we talking about downloading from pirated site, copying from illegal sources, and use for training? There's multiple copies involved, so it's going to be kind of a slightly different analysis each time. Really, where it gets disputed is the training transformative. And the arguments on the other side are it's not being used for its expression. It's being transformed into statistical weights and measures and numbers and things like that. My position, and again, I didn't say my disclaimer at the beginning of this, but that everything I'm saying is my own opinion and not that of my firm or my clients. My position is that it is in fact being used for its expression, because large language models need high quality, long form content to be able to predict what and how to express human language. So I don't actually think it's transformative, particularly because it can and is being used to generate what essentially are market replacements. And that's where the fourth factor kind of blends into the first factor, whether it's generating competing works and talking about market harm in the market for that particular product, or the loss of licensing opportunities for this market that we talked about before, that I indicated kind of already exists and continues to develop, the market for licensing creative material for AI training. So my opinion is that all four factors weigh against fair use, but I don't wear the black robe. So all I can do is be an advocate and see where the judges go with this.
Yeah, turning to litigation, more broadly speaking, our there any recent cases that have had the most impact on copyright litigation, in your opinion? And if so, what implications has it had on your practice and advice that you give to clients deciding to litigate a claim?
I mean, obviously the Warhol decision, I guess, was kind of a big one. I was the first copyright decision coming out of the Supreme Court in a long time since the Oracle decision, I guess. I don't know that it really changed a lot in the fair use landscape. I mean, everybody is citing it for their own purposes, right? Everyone says, "Oh, well, Warhol favors my position because of X, Y, and Z." It did clarify a bit what constitutes transformative purpose, but you didn't really get into transformative expression, the degree in which something must be transformed in terms of adding new expression. So I think there's still a debate about trans- transformative use. But I think that's a very influential case, again, that everybody is citing for various purposes. The Neely versus Warner Chappell decision concerning the discovery rule and the damages look back, I think it's definitely important, assuming the discovery rule remains in place, right? The notion that damages look back is not limited to 3 years is really kind of important for plaintiffs. Whether the Supreme Court takes on the question of whether the discovery rule actually is a thing and should exist, that's going to be a really big deal. I think that's the Greco case. I don't think there's been a decision on cert yet on that one. But the statute of limitations issue has been thorny for many years, and I think that potentially could be one of the biggest changes in case law and can influence a lot of litigation. It's going to, whether you have a discovery rule or an infringement accrual rule, is really going to impact the ability of plaintiffs to bring claims, and it's going to impact the way in which defendants defend against claims on timeliness grounds.
Yeah, there's like dissenters that argued that there is essentially like no look back on the discovery rule, right? That it doesn't withstand like long-term infringement. And it's at the 3 years, right? The injury rule was pretty like cut and dry in the statute, and that it only lasts for that 3 years, right? It doesn't look back at past infringement.
Yeah, I mean, the statute doesn't say that. It doesn't say that there's a discovery rule. It just says it's 3 years. But the question of accrual, I guess, has been more of a judge-made determination in a lot of instances. There are other federal laws that may have discovery rules, but you've got a court that is taking an interesting position on this, because you've got some justices that basically say it's not in the statute. So how can we read that into the law when it's not in the statute? I don't know that is that cut and dry, but yeah, it'll be interesting to see if they take up this question and where it goes, because I can't predict it. The super majority of this court seems to be more of a originalist, strict constructionist view, but you never know. I mean, where they're going to come out on these issues. They're certainly not drawn on partisan lines. So you could have an unpredictable result. It'd be interesting to see where it goes.
Where did that come from? This idea that you can sue for past infringements and then subsequently discover it later, and then go back and look at things from long ago, but you didn't know about it. So now you can bring a lawsuit. Is that a court created approach? Or was it something that was derived through good arguments?
As far as I know, it's court created. I mean, I think I don't know whether there are statutes that have discovery rules built into them. I'm sure there are, but to some degree, it's court created, because there is nothing in the Copyright Act that says that provides for a discovery rule. So judges had to have come up with it maybe as a rule of kind of equity. When somebody is unable to discover an infringement, it's not fair to prohibit them from suing because they waited too long and they didn't know about it. On the other side of that, if they kind of should have known about it, it was very obvious, it was out there, it was kind of open and notorious, it kind of goes the other way. So that's why the discovery rule is usually framed as that the statute starts to run when the person knew or reasonably should have known if they had conducted diligence. Unfortunately, it's a hard argument to make on a motion to dismiss because it can be fact intensive. I don't think it's impossible, but it's usually kind of punted to post discovery. You got to find out, was it reasonable or not? What diligence did they engage in? Should they have known based on what standards? So it's all very kind of equity based. So yeah, I would say it's been developed in the case law. I don't know where it originated in the copyright context though.
Yeah, I mean, the Neely case was interesting because the plaintiff was in prison and he had this track that he had recorded in the 80s, and then it was brought back by some big artist in hip hop songs, and he didn't know about it. And then he was able to bring that claim after discovering it. And then I think that there's a slight desire, maybe the courts have, as you were saying, on the equity reasoning. It's fair, and it's a fair approach because some people may not have a 3-year cutoff because of attenuating circumstances like prison. So,
Like being in
I-
prison.
yeah, I agree. I think I would hope that it survives as well.
Yeah, it's hard because I can look at it from both perspectives. I represent parties on both sides of the V. So it's good and bad for depending on which side you're on.
Agree with
Yeah, I
that
think it
too.
also-
Just by the way, I don't. Yeah,
Yeah,
I would say I agree.
I think there's something to be said for potential bad actors who also might be trying to conceal the infringement. And I don't know whether it comes up in the context of fraud or other claims like that. But if somebody has kind of actively concealed or prevented a plaintiff from discovering something, obviously they should have the opportunity to still bring their claim because it was no fault of their own that somebody was hiding.
Scott, you touched upon various approaches to litigation, pitfalls to avoid, and being able to determine that not everything is black and white. There's a lot of very complex areas. What would you say is the single best piece of advice that you'd give to a new litigator who is a newly minted law graduate or they've just joined your team? Is there something that you wish someone would have told you when you first started practicing law?
You mean in terms of for litigation specifically?
Yes, I would say just in terms of the technique behind litigation.
Yeah, I mean, I think this is just my personal approach, and it's not necessarily something that I wish somebody had told me otherwise. It's just the way I generally approach things is it's an adversarial relationship, but it doesn't have to be nasty. It doesn't have to be personal. It doesn't have to be unnecessarily aggressive. Like my position is that we're in a job, we represent clients, we want to do what's in their best interest. And what's in their best interest isn't always fighting every single fight or being as aggressive as possible on everything. I try to take a more civil approach to civil litigation. I try to be as approachable and collegial as I can. Obviously, that can only go so far. I'm sure you both have dealt with your share of people that just doesn't work, and you have to respond to aggression with aggression, and that's fine.
That's what sprang to mind when you first introduced this idea. I'm like, but wait, there are people that are terrible.
Yeah, there's plenty of them, and you have to change your approach when it comes to people like that. But my default is to start with being as civil as possible, and I think it's an important thing to understand that you can be civil and still be a zealous advocate and aggressive in certain ways. I guess this kind of brings me around to the concept of understanding the client's ultimate goal. And so maybe this is the thing that I think somebody should articulate early on to a new lawyer is you need to really drill down on what the client wants. What is the end result that will make them happy or will satisfy their need for either a principal victory or a financial victory, or fighting every fight is not necessarily the best way to do it. Typically they're paying you by the hour. Do you really need to fight over every single document that you are claiming is not responsive? Do you really need to fight over the schedule on this, that, or the other thing? And this actually came from an in-house lawyer at a conference I was attending, who was articulating this from an in-house perspective, saying, you might think it's a victory because you won this discovery dispute. But when the client sees the bill, they're going to say, well, what on earth was that for? And you'll say, well, we won this motion and now we don't have to produce these 10 documents. And the client could very well say to you, but I don't really care. Like you could have, produced those documents and saved me 30 grand on motion practice. So clear communication with the client about what they want and what your proposal is and what you see as a victory, and making sure you're aligned in your goals, I think is really important to maintaining client relationships, but also getting the best result, not only in court, but financially for the client and in terms of maintaining a relationship.
That's really interesting. So turning to the topic of the current system, I know earlier you had discussed the high cost of litigation. Do you think our current system makes it easy for artists and creators to protect their rights? Or maybe it falls short in doing that? What are your thoughts?
No.
That's it.
Right. Next question. No, I don't. And that's one of the most difficult parts of this job, especially in representing creators who are at all different levels of financial ability in all different walks of life, from individuals and small businesses to all the way to even the biggest media companies are cost conscious and don't want to spend millions of dollars on litigation. Every so often you get the company that will litigate on principle, even if it's not a good financial decision, and that's fine. But I think I gave the example before of an individual or a small business has either their copyrights are infringed or a contract was breached and they're owed $200,000, and that's real money. And it's also going to cost them $200,000 to get it back. So what's the point? Like it's very frustrating sometimes to express that to clients who feel very strongly that they've been wronged or that they've been accused of something that they're not, that they deny that they're responsible for, and encouraging compromise and settlement when they really think that the situation is unfair. When at the end of the day, a settlement financially would make the most sense. So you don't have to pay hundreds of thousands of dollars in legal fees to potentially get nothing or get a lot less than you had hoped. Or even if you get everything that you want, it cancels it out because you spent so much on it. I think it's really unfortunate. And so, yes, it is difficult for artists who don't have all the means in the world to enforce their rights. So sometimes they have to go to organizations like Volunteer Lawyers for the Arts or get pro bono help or low bono help. There's also the Copyright Small Claims Tribunal, which you don't need a lawyer for, and you can still get pretty significant damages for an individual creator. It's certainly not as high as you would get in court, but there are alternatives. And I think the Copyright Claims Board is a good one. And I wish there was more awareness about it and people used it more than they do. Being in a kind of an opt-out system, it's a little difficult to really encourage people to do it. But there are ways, but most of them are really expensive.
Do you ever steer clients to like mediation or arbitration and use alternative ways of settling the dispute?
Yeah, I like mediation. I've had some decent results from mediation, especially court overseeing mediation. So Southern or Eastern District, they have great magistrate judges that are very skilled at settling cases. And if you don't want to use the magistrate judge, you can get somebody from their panel. So I think that's a good way of doing things. I've had varying experiences with arbitration in terms of cost. Arbitration is supposed to be less expensive than court. Sometimes it is, and sometimes it isn't. I've had cases that from start to finish, far less than it would have been in a courtroom. And I've had other ones where it's basically been the same. And so it really depends on the facts and the arbitrator and how complicated the issues are. So I think it's a good option, but I don't think it's guaranteed to be more cost effective, even though it's supposed to be.
Is there like the incentive for like civil litigation, maybe like to get headlines to bring attention to it? Is that one consideration that ever comes into play?
I think so. Yeah. People want their story out there, especially on the plaintiff side. If they feel like they've been wronged and something requires media attention. Yeah, that is it. Having a public filing, I think, is certainly a consideration for some people.
Scott, you shared previously that the importance of an attorney's job, a litigator's job, is to ensure that the client's best interest is accomplished. And with that, you've had quite a few accomplishments in your career. What would you say is one specific accomplishment that you're most proud of? And what's something that you did that made it possible? There's quite a few, so you can choose which one is the most memorable or I guess the most significant with respect to your career.
So I look at it kind of in two different ways. One is litigation victories, and the other is kind of client victories, not necessarily in litigation. I mean, I get a lot of satisfaction working with individuals and smaller businesses, and the, these things are these disputes are meaningful for them. Like even getting like a small amount of money back from somebody that they feel like has done something wrong is really important for them. So I've had a number of those situations, but I think in terms of like just pure litigation victories, I had a copyright case that went on for a couple of years over digital interactive art installations. And we had an initial summary judgment decision that did not go our way, but the decision was based on an argument that was not raised in the papers. And so we, knowing that motions for reconsideration are rarely granted, we took the chance and presented the evidence that we would have presented had we been given the opportunity under Rule 56. If a motion for summary judgment is decided on a basis, not the papers, you're supposed to be given notice and be allowed to essentially supplement the briefing. And so we convinced the judge to grant reconsideration. And then a month or two later, a summary judgment decision came down almost entirely in our favor, finding acceptability of the work and extrinsic infringement based on expert testimony. The case ultimately settled. So that was kind of a big emotional roller coaster for me. And I remember very clearly, and my kids even remember this, the night that the order granting reconsideration came in, my jaw hit the floor when I was looking at the ruling on my phone. My kids were like, "What is it? What happened?" And I had to kind of explain it to at the time, 6-year-old and 9-year-old, what had happened. And they still remember that to this day. So that was really fun. And then in the non-copyright, I had a pro bono client when I was at Paul Weiss, an immigration client he came from Jamaica and was as a gay man in Jamaica was subject to lots of threats of violence, physical violence, threats of violence, all kinds of horrible things. And so we got him asylum, and then we got him his green card, and trying to remember if I helped him with his citizenship application and if I was still there at the time. But working with him and really learning his story and putting those papers together really was one of the first times that I fully took over and took on a matter and a client as a junior lawyer, and getting him that petition granted was just like one of the greatest moments of my career, because I knew, okay, he doesn't have to go back there and put his life at risk. And so that was quite moving. I was on my honeymoon at the time the decision came in. And I remember being in 10 hours ahead or something like that, and just waking up and frantically checking my BlackBerry at the time, knowing that the decision was going to be rendered that day, and just like jumping for joy when I saw it. It was really quite great.
So rewarding.
It's a plug for pro bono too, and especially for lawyers that are doing something that they're bored with. They can always find pro bono work and find something meaningful that inspires them.
Yeah.
So turning to Taekwondo, you're a 3rd degree black belt and you're working towards your 4th strike. I think you called it obtaining master status, and Taekwondo has been a part of your life for many years. I'm interested, how have you managed the demands of a legal career with being able to continue earning stripes and maintaining your black belt in Taekwondo? And what is one takeaway you've gotten from Taekwondo that you brought to your practice as an attorney?
So how I do it is I don't sleep. And we're talking about music before. I play music. I, I make art. I have like too many interests, right? And so the unfortunate side effect of that is not sleeping. And the Taekwondo is part of it too, especially around times when you're training for a specific kind of test or promotion. So I find the time. I joke that I don't sleep, but I try to find pockets of time where I can do things that are personally satisfying. And Taekwondo is one of those that's I've been doing it on and off for 30 years. I mean, I was like 12 when I started, and there were times when I wasn't doing it as much, like during college, law school, and things like that. But what kind of got me back into it was moving up to the suburbs in 2019. I wanted to get back into doing it again and getting my kids into it. And so both my daughters do it. And my older daughter got her first degree black belt last year. And so now we can go to class together. And so that's one of the things that I really enjoy going to class with her and actually being able to be in the gym with her. So it's always been a part of my life. And my mother had always said there was a change when I was a teenager. When I started doing it, I became more disciplined. I became more focused. I gained confidence. And she always swore that was a kind of a turning point for me in terms of setting my personality and really kind of changing the direction I was going in, and got more organized my schoolwork. And again, she attributed it in part to that. And it's one of the reasons that I've stuck with it, is because I really think it has been a very positive influence on my life. And what was the other question you asked?
What's one takeaway that you've brought from Taekwondo to your practice as an attorney?
It's interesting. I never really thought of that. I don't think consciously, but I think it factors into the kind of adversarial fighting aspect of things, where you don't, I think it's consistent with my philosophy that you don't have to fight every fight, and you don't have to use all the force that you're capable of using unless you really need to use it. One of the things that you learn is that martial arts, at least in my experience, is primarily for defense. And I was always taught that you're not to be the first aggressor. And it's not Cobra Kai. We're not strike first, strike hard, no mercy. Like that's as cool as that sounds. That's not typically the philosophy that I've been taught. And so you learn to choose your battles, and to be civilized when you can, and to throw punches when you need to. That doesn't necessarily mean you always have to be on the back foot, or that you have to concede to people, but you have to be wise about when you use force and when you don't. And so I think there are some good analogies to practicing law, and especially in litigation. It's like, when do you defend? When do you attack? Can you predict what your opponent is going to do? And part of sparring in Taekwondo is seeing if somebody telegraphs a move and trying to predict what they're going to do and how you're going to counter. And so, yeah, there's some parallels there, I think. It's really interesting. I never actually thought of those parallels until you asked the question, but there they are.
Given the very busy spring season that you've encountered, what's next for you this summer? And do you have any recommendations for listeners to add to their summer reading list, or even their Spotify playlist? And why would you recommend them?
So I'm really into like sci-fi and fantasy and horror and things like that. So one series that I can't say I read it because I listened to the audiobooks, it's called Red Rising. It's by an author named Pierce Brown. It's just this epic science fiction universe. I think there's 6 books right now. We're waiting on the 7th one. It's just fantastic. I mean, the writing is great. The story is great. The characters are great. It starts off as, there's almost like a Hunger Games type aspect to it in the first book, but it's just so much more than that. It's just this epic political drama with all kinds of great space battles and all kinds of cool stuff. And the writing is amazing, and the characters are fantastic. So that's the series I usually am pitching. So I've really loved those books. And music, it's hard for me to recommend music because my taste in music is not most people's taste in music. I listen to a lot of heavy metal and punk, and as much as I espouse kind of civility and selective aggression, like I listen to very aggressive music. trying to think of some of the stuff that I've been listening to lately. So actually, this band that you can see I'm wearing a shirt is called Unleash the Archers. They're a Canadian metal band. It's not super like scary or heavy. Great melodies. Like I don't know if you've heard of power metal. It's called power metal. It's like very kind of operatic and fist pumping kind of big melodies. So they're one of my favorites recently. I also listened to a band called Ghost quite a lot. I'm seeing them in July. They're a lot of fun. Also another kind of big stadium rock, like fist pumping kind of stuff. But I often go back to classic bands for me, like Metallica and Megadeth and Iron Maiden and Black Sabbath, and those kind of bands are staples of my playlists. And so you can't go wrong with the classics as far as I'm concerned.
Well, Scott, this has been a great discussion. If you could leave us with one parting thought about AI and copyright, what would that be?
Grab the popcorn. It's going to be an interesting ride. I think the dust will settle, and I'm optimistic that things will work, because they always have, right? And as technology develops, it happened with music, it happened with when the camera came along and when Photoshop came along. There are these sea changes that happen, and everything is crazy for a while, and litigation goes nuts, and some things are resolved and some things are settled. But I think there is a world in which both can exist and everyone can accomplish the goals that they're looking to accomplish and make a living. And so maybe it's a little, I don't know, Pollyanna of me, but I do believe that there is a way to make this work just based on past experience in history. So keep watching it. It's going to be really interesting.
Scott, thank you so much for your time. We really appreciate it.
Yeah, of course. Thanks for having me. This was great.
Thank you for listening to this episode of the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the City Bar. If you enjoy this podcast, please like and subscribe wherever you listen. Find more City Bar podcasts on Apple, Spotify, YouTube Music, iHeart, or at our website at www.nycbar.org/podcasts. Be sure to check out This Lawyer's Life, a professional development podcast where we talk with lawyers about seizing opportunities, learning lessons the hard way, and about what makes them tick. And don't miss Building Belonging, a podcast that embraces authentic conversations about DEIB solutions by amplifying the most marginalized voices in the legal industry and exploring spaces others dare not. This podcast was produced by Eli Cohen and edited by Jalen Martin.